This time I don't want to test it.
So she's not going to take the stand. That's a big surprise. Really sucks Kappelman would have destroyed her. It's the Donna Adelson trial. Dan Markel, the father of Benjamin and Lincoln, was murdered 11 years ago. It's all led to this. Donna Adelson is charged with first-degree murder. If convicted, she faces life in prison without parole. We'll use our law enforcement experience to comment on the case as friends, family, and the people seek justice for Dan Markel. All that and what it means for your weekend on the Comm Center. Wake up, America. It's the Comm Center with Drew Breasy. It's a TV show on the internet about two best friends who are called by a small town sheriff to investigate when a camper goes missing in the woods. However, the boys have to decide whether or not to pursue based off of whether or not there are snakes or spiders in the woods. Normally, I'm joined by my podcasting partner with police benefits. That's Drew Breasy, a longtime police detective guy. However, he has tonight off, and I'm doing the show by myself. I'm John. I'm an actual 911 dispatcher. I've been doing that job in my community for 10 years. It's day 11 of the Donna Adelson trial. The biggest news of the day is that the judge told the defense that they have to go on the record for whether or not Donna Adelson's going to have to testify.
Concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her?
The short answer is we were.
If I may, Judge, the issue is that we...
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
We have not had an opportunity.
You did not speak with your client concerning whether she wished to testify or review the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced at this moment as the defense case in chief ends.
I'm asking for additional time to be able to go through all of the testimony.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. It is time for the decision to be made.
I can tell the court that co-counsel and my client are deep in conversation concerning this.
I am capable of seeing that, Mr. Zellman. No narration is needed. At this point, I do need a decision. Mrs. Adelson, please rise. Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial.
I don't have to choose. I was hoping I would have some time to speak to my attorney.
This has already been discussed, ma'am. What is your choice?
Get on with it. Yes, get on with it.
Judge, since I was handling the prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today? I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains.
Enjoying this scene.
Get on with it!
As it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
Get on with it!
This time I don't want to testify.
It is no surprise that given how vicious, incompetent, and wonderful, frankly, that Georgia Kappelman's prosecution has been on this case, that Donna Adelson is now scared to testify. She knows that if she gets up there, every single thing that she said is going to be destroyed. Asking questions like, why did you have Dan Markel's license plate in your journal? To how come if you were coming back from Vietnam in time for Lincoln's bar mitzvah, why didn't you just go ahead and buy the tickets? Why wasn't that plan put in place at any point? Every single thing that she's been doing this week to try to mitigate the state's case against her will be instantly destroyed over the course of a couple hours. Putting her on the stand is the same thing as surrender. Hey, before you do anything else, make sure you're doing all those YouTube things. Make sure you hit like, make sure you hit subscribe to keep up with the Comm Center. We answer 99.9% of comments, so make sure you leave yours below. Very, very, very disorganized, and what's not disorganized is boring. Today was an amazing day where they tried to relitigate Dan Markel and Wendy Adelson's divorce to decide whether or not it was actually contentious, whether or not the relocation issue was settled or not settled or worth killing Dan Markel over. It was a ridiculous day where a lot of stuff happened outside of the presence of the jury. And Georgia Kappelman and the judge are getting fed up with these shenanigans. But let's go back to the very beginning of the morning where we had something unusual going on. The day starts, just stuff's happening. The defense is trying to make some motions that someone who was going to just willingly testify before the defense was told not to. This would have been a jail deputy or a correctional officer. Told her that she had better not comply with the defense, better not go along with them, as it would be bad for her job. As you can imagine, it would be. She works for the state, and why is she just randomly volunteering to testify for the defense? So she was told, apparently the defense is saying she was told not to do that, and then she disappeared. She just immediately went on leave. The state disappeared her. They actually brought in the undersheriff, the number 2 guy, to testify. We'll go after that. But the judge ruled that ultimately it's the defense's fault for never subpoenaing that person in the first place. We'll see if they end up trying to get that done. But let's watch the footage from this morning.
Who are either not under subpoena or not listed witnesses. There's not very much I can do.
Judge, it is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense.
He's trying to imply this is some kind of witness tampering. I think it might only be witness tampering if there's a subpoena. I think they were just trying to give her some career advice that maybe it's a bad idea to just volunteer yourself for the defense. Not sure, though.
We are asking for the court's assistance because the rules...
To do what exactly?
By the way, this would not be the last time today he begs for the court's assistance. He needs all the help he could get. He's like, Judge, I'm having a real hard time here. If you could jump in, that would be great.
So that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
Thank you.
Undersheriff Google, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give to be the truth?
Yes, sir, I do.
If you can just stand in front of the court reporter instead of taking the witness stand. If you can explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
So the undersheriff's the number 2 guy. I think it's a weird title. I prefer chief deputy, but you have to have sheriff in your title to feel good about yourself, and you also have to have as many stars as possible. Really? This is how you could tell cops love dressing up in their costumes. The 3 stars? Come on now.
To my knowledge, I was approached by Captain Georgia Dent, who had spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Adelson's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with General Counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
Any examination for under Sheriff Google by the defense or state?
Not from the state, Your Honor.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
So it seems pretty straightforward to me. She had the chance to testify, or she was asked to testify, and maybe she asked her superiors or some people there at the jail, what should I do? And they went forward and they asked their own lawyer, like, kind of what's the situation there? So you're talking to another officer of the court, another member of the bar, what position should she be in? And I think they basically said, it's up to you, whatever you want to do. I guess we'll find out if she immediately went on vacation afterwards. If it were me, I would want to be subpoenaed. I wouldn't want to go up there voluntarily just because I don't want to get into the middle of things. If I had a piece of information that I thought was really, really important to the case, like if I had exonerating evidence, like if I knew for sure that Donna Adelson didn't commit this murder, I would be going to the state's attorney's office and letting them know that, because they would have to turn that over. But I would be going through my own side. The jail deputy's on the side of the prosecutor. Let's go on with the substance of the testimony this morning. It was really interesting. Like I said, they brought Wendy's attorney, who helped litigate everything, all the divorce and custody matters between Wendy and Dan. And she kind of tells the story about how after the divorce was settled and Dan was supposed to be paying a certain amount of money, and then he stopped and he accused Wendy and this lawyer of both committing fraud, which is a pretty bold thing considering they're all members of the bar. And she just came up to talk about how that went. Was the divorce contentious?
6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children, consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
All right. So the entire morning went on that way. It was very, very boring. They relitigated the whole thing. I don't know if Drew went over this yesterday. I don't think that he did. But yesterday we saw some real buffoonery on the part of the defense. Basically, they had a witness that needed to testify probably right before lunch, I think. He was, I think he was a realtor involved in some of the housing stuff that was going on. He might have even been Dan's realtor. I don't know. But the point is that there's a rule of sequestration in effect, and that means that anybody that needs to testify in this case cannot be in the gallery at any point, because they would be hearing other people testifying, and it could possibly taint or alter their own testimony, right? So that's the rule of sequestration. We can't have witnesses, upcoming witnesses, sitting in the back of the court. Well, yesterday, the defense mismanaged their own witnesses so badly that this realtor was sitting in the back, and luckily we have like really observant bailiffs who are paying attention to this and say, hey, this guy was in the gallery. We've broken the rule of sequestration. The judge was kind of pissed about it because you're not supposed to do that. That's not the mark of a professional lawyer. It's not the mark of a lawyer that adequately preps their witnesses. But I mean, we saw a lot of that yesterday, right? When you watched Miss Cunningham, the first person who was on the stand, who was constantly being prompted to engage in hearsay, you could tell that she wasn't the best rehearsed witness, that maybe they hadn't gone through with exactly the format of questions and answers and how she's going to have to tell her story without saying what Donna Adelson or some other third party said, right? Because that's hearsay. So the defense lawyers just seem buffoonish in the way that they are not prepared. And guess what? It happened again. And this time it's a bigger deal. and the judge is pissed.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
The defense is begging. He's basically saying, hey, at one point at a sidebar last week, we actually worked it out so that this would be okay with you. And that's not what the state agreed to. The state agreed to have an adverse expert come in. Basically, that the defense is going to have an expert testify on their side. They never agreed to the fact that this expert witness was going to be allowed to break the rule of sequestration and sit in the gallery and watch the witness that went right in front of her. So now there's a big problem. We've got yet another witness who's broken the rule of sequestration, and what the Supreme Court has ruled that the judge has the power to exclude this witness. If he thinks that that witness breaking that rule of sequestration is going to alter their testimony and thus the outcome of the trial, they can just exclude that witness. But that's the most severe remedy. It's like ejecting somebody from a baseball or football game. You have to have enough unsportsmanlike conduct violations before that'll happen. It's the biggest thing that the judge can do, and it's the biggest grounds for reversible error. So the judge has a big decision to make. The state's going to say, well, we keep having this problem. We keep having people in the back of the courtroom when they're not supposed to be there. I would rather have this person excluded. I'm not convinced that I'm not convinced that Georgia Kappelman is actually afraid of this person testifying or that she can't handle him. I think she just sees that they could get to the end of the day faster if they don't have her in court. But let's see what the judge says.
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual or even brought up this topic to make sure we did not end up in this point and place?
Judge, we thought we adequately addressed it last week during the sidebar.
Ms. Kappelman, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy, but you did admonish the defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So.
As to your point of the state getting a fair trial, Ms. Kappelman, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Last word.
Reviewing Earhart, exclusion of the witness. Court may exclude witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected?
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
So they're going to have Bailey approach the stand. They're doing this because she's a member of the bar. You think that you can trust a member of the bar. You think that they have integrity. Spoiler alert, I'm not going to be impressed by her integrity today.
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc., in the Adelson-Markel divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
Does this seem unusual that we're going to have an expert come in and decide whether or not it's contentious? I mean, Kappelman's going to get to this, and we'll show it all. We're going to have an expert come in and decide whether or not something's contentious. Contention is a feeling that the litigants have. It's what Wendy feels. It's what Dan feels. It's what Donna feels. Someone who's an expert in handling these kinds of cases is going to become really unaffected by those things, and I don't think they'll be able to decide whether or not those are contentious. I'll use an analog from my own life. I'm a 911 dispatcher. I handle emergencies every day. I handle the worst things that could happen to a person. I handle the worst things in their life. I don't even remember those things the next day. You know why? Because they happen every day for me, insofar as that I'm a 911 dispatcher answering those calls. So when someone calls me and they dial 911, is it up to me? Do I even have the ability to decide whether or not that was the worst day of their life or not? Probably not.
Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your preparations?
I think so.
The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony.
This is the judge basically saying it's not really my decision to make. I can't go with my gut onto whether or not this would make a big difference. There's already case law that will decide this, but he does mention the fact that she's a member of, that she's a lawyer. That's part of the reason why they're going to go ahead and allow it. I'll allow it.
The witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters.
I think he understands why the state's asking for her to be excluded, because the defense just cannot get their shit together, and they keep kind of messing up the trial. But I think the judge realizes that if he rules in favor of the prosecution on this, it'll actually, as I said, be grounds for a reversible error, because it would be the biggest decision that he made on the case. And a lot of judges, it's just too close to call. They might not go along with him. So here, in the middle of all this boring testimony, the defense attorney knows that this is very boring. So we're going to go to do an old-fashioned stunt. We bring in all the letters to Santa Claus. These are all the files from the divorce, by the way.
Volume 1. Volume 2.
This is allegedly everything that she's reviewed.
Volume 3. Volume 4. Volume 5.
There are questions of the witness.
Do you recognize this file?
Yes, I think I forwarded this to you.
And this are these 10 volumes, a example of a hotly contested relocation case.
Well, and I just count 500 pages per binder, so that looks to be about 5,000 pages. I think the actual pages were over 10,000, so this doesn't appear to be all of it.
Okay.
And there were 2 volumes on the record on appeal, so...
This is a classic example of how she's going to behave the entire time. It's very tiresome. Someone will put a question to this woman, and she will not answer directly, yes or no. You've seen the cops testify in this trial. They say yes, they say no. Sometimes they get asked a yes or no question, and they say correct. At least they know that their answer should be one fucking word. Not like, well, I saw more than this, and I saw more than this. His question is, does this look like all the paperwork of a contentious relocation hearing? I haven't heard a yes or no yet.
Only one of those volumes got printed.
So the clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
Thank you.
Please sit down, Ms. Bailey.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Kappelman is like, I object on the basis that this is very boring and irrelevant. He just went through this whole dog and pony show of having all these files brought up and having her say whether it was a lot or even if it was even everything from the case. And Kappelman says, gosh, Judge, what's the relevance?
Sustained.
Judge, may we approach?
No.
He said no. He said you cannot approach. The judge is so sick of it. Him doing all this bullshit, all this very poor lawyering. And every time the judge does something that he doesn't like, he wants to talk to the judge privately about it. He wants to litigate everything out with the judge. And the judge is not having it anymore. And listen to the jury's response. They laughed. And the person on the stand smiled and laughed. And probably Georgia Kappelman laughed.
Judge, we're entitled to make a record. I believe I have the...
Members of the jury, the bailiff will take you into the jury room.
And he's just like, oh my God, get out of here again, guys, for the 1,000th time. I actually am seriously concerned about the level of snacks and about the well-being of the jury because they're probably eating quite a few Twinkies in this trial.
This witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
I was just doing a cheap stunt. I was trying to make this boring testimony seem somewhat interesting. You have to give that to him. Fulford says, can we approach on a separate matter? She wants to talk to the judge and admonish everyone for laughing at the defense because when Zelmer asked to be seen at sidebar, the judge told him no and everybody laughed at him.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with.
That's not the answer to the question. The answer to the question is, yeah, for them, it was the biggest thing going on in their lives. They only had one divorce. For them, it was personal.
Right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
This is lawyer versus lawyer. It's been lawyers versus lawyers the entire day. We've had lawyers on the stand. It's getting very irritating because although they are members of the bar and we can apparently trust them to testify and be honest members of the court, Bailey is completely in the bag for the Donna Adelson defense. and she's not willing to give an inch whenever Georgia Kappelman asks a question. She won't give a simple yes. Like a human being besides me might actually have a thought or a feeling that I don't know about. Or maybe as a professional, I don't take into account what everyone's feelings are as I dig and read through all their many binders of testimony.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties, it's the most important thing in the world?
To some degree, that's one reason I called Kristen.
Just say yes.
Is Miss Adelson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions that.
Okay, so you're a good lawyer, and you litigate against other good lawyers to kind of grease the skids and make divorces as easy as possible. But what happens at 5 p.m., right? Everyone leaves the courthouse feeling happy, healthy, and like everything's well in hand and like it's all going to work out. But then they go home and then they open up the Jim Beam and they read through all the emails and they get, the latest motion in which someone's called gibbers or whatever else. And they might feel contentious about it. And they might feel like they're going to fight this tooth and nail to the ends of the earth. They might feel contentious about it in the hours which you're not billing them for. And that is what makes it a contentious divorce.
People stay measured and calm and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy.
The thing that they testified to all day is that Dan Markel was refusing to pay money that he was apparently owed to Wendy, and that he was filing big motions like the grandma motion in order to keep Donna out of his children's lives. He was filing inappropriate motions, very emotional motions, stuff that he'd obviously done on his own behalf without consulting his lawyer. That stuff's all emotion driven, and it's what the essence of contention is. It doesn't matter how good these lawyers are, and it doesn't matter how good they can grease the skids. Wendy and Dan were contentious over the relocation of the children and the division of property. If you go back to Wendy's interview, when they bring her in and just hours after Dan is murdered, the detectives ask her, did Dan owe money to anyone? Did he have any gambling debts? She says, well, he owed money to me. So it was contentious enough that even though he was dead, she still thought about how he owed her money and how now that might affect her maybe not getting paid as soon as she wanted to get paid.
But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but...
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
Does she sound professional? Does she sound like a member of the bar? Does she even sound like a lawyer? Well, I know from the pleadings. I think we all feel like Georgia Kappelman does right now. This person should have been excluded from testifying just because they're unprofessional. I know that's not really a good reason.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
What were their emotions, though? You know, as they reached some compromise and reached some agreement, they eventually did get it done. What was that process like? Because it wasn't amicable.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
Yes or no? I would honestly object. She's not answering this question, Your Honor. Can I instruct you to have this witness answer?
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
I don't get it. This is how you know she's completely in the bag for Donna Adelson, because that analogy was perfect, right? The garbage man comes by and he picks up your garbage. And is it stinky or is it not stinky? Well, what did he pick up down the street? What did he pick up next door? What's the worst bag of garbage that he's ever picked up? What's the worst thing he's ever found in a bag of garbage? You know, it's not up to him to decide whether or not your trash can smells bad or not. Because if you open up the lid and stick your head inside, it might stink. But she won't agree even to that. She's, I don't know. She's completely in the bag for Donna Adelson.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that. You can't agree with it.
Perhaps. I don't know. Doesn't it amaze you that we have this state's attorney, this prosecutor, who seems to understand with more empathy how court cases affect human beings? This is great.
Strike the question. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful.
Oh, I guess that was contentious, right?
Literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey.
derived.
To that person, it was a reason to commit suicide, right?
It was a matter of life or death. And if divorce is a matter to kill yourself over, perhaps to others, divorce and custody of children is a matter to kill someone else over.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
She's just not answering the question. I mean, she's not a good witness for the defense, to be honest, and she's not a good lawyer, and she's not a good professional. She's just bouncing it back. Non-responsive.
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal. It wouldn't be granted. It was buried in there. But the allegation is grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't.
Exactly.
It shouldn't have been. There was no proof.
So in other words, it should have been. Donna Adelson's not entitled to her own feelings about it because everything was going fine.
It shouldn't have been, in your opinion.
In my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
That's not what is at issue. Just the fact that other people call each other fuckface and dickhead and the C word and all this other stuff, none of that matters. And if this person's an attorney, she should realize that. She should just say, instead of saying, well, I've heard worse, or no one should get mad about this because worse language is used elsewhere. How does it make the litigants involved in this case feel? It might be the worst thing that they can possibly be called.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss?
It is to the jury. It is to the jury. And if Bailey's smart, she'll say, yes, it's a lot of money. No doubt.
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
Yeah, I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
Do you see how she sounds? Oh, he was going to pay. She's all in on the Adelson side. And what I love about Cavalman here is that she's actually using her expertise against her. She's saying that because you're an expert, you can't understand how the common person feels when they're going through divorce. It's all just bread and butter to you.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay, well, you sat in the courtroom during Ms. Adamson's testimony, didn't you? And Ms. Adamson said that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But
ultimately.
Wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms. Adamson was incorrect on that point, I guess.
Objection, Your Honor. It's not a question I need to strike. It's an improper comment on the witness's testimony.
Stay and please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down.
She can't just say yes. If she says yes, Miss Adamson was incorrect on that particular point about whether Dan Markel ever faced jail time for his non-compliance with orders of the court, it would be to impeach the prior witness and her credibility. So she's turned one lawyer on against the other lawyer. Cappelman does an excellent job here. And rather than answering yes or no, this attorney goes on forever about it.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All could have worked out.
If he was murdered, it could happen, right?
Well, obviously.
No, that's exactly what happened.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended.
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Yes, but it kept going. The divorce was over, but they kept filing proceedings. And if Dan had not been killed, there would be truckloads of this stuff. So for them to say, like, this is only a small amount of paper, this isn't very much, it wasn't that contentious. This looks like a lot, but, when it comes to lawyering, this isn't that much. And Keppelman's saying, like, well, the case was cut short because Dan's in a box in the ground. Hello?
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th he filed the motion that accused Kristen of fraud, so she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection or calls for speculation.
Now he wants to object, calls for speculation. We don't know what would have happened. Okay. Which seems fair, but Miss Kappelman asked, there would be nothing stopping him, right? If Dan were alive, there would be nothing stopping him. That's a yes or no question. That doesn't call for speculation. As long as someone's alive, they can litigate to the ends of the earth until, of course, something is dismissed or ended or stipulated with prejudice. But of course, you can always litigate something else. Unfortunately, Dan is now post-litigation because he's been killed.
So
But that hadn't happened yet.
it had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
May I have a moment to confer, Judge?
Clearly. Do you think the jury likes her in that moment? When Kappelman's basically saying, you know, he was filing these nonsense motions and it was, you know, they were going back and forth and was it a big deal? Wasn't a big deal? Ultimately, we'll never know what kind of a big deal it was. We never get to see the totality of the case because Dan was murdered, right? Clearly. There's no empathy in the voice at all. She seems to have disdain for Dan and that she's even being put in this position. She's 100% in the bag for Donna Adelson. I don't see her as a clear and impartial person who's testifying. You know, we've had other experts in this case. Yesterday, we had a cell phone technology expert come up and testify for the defense. She used to work for the police. She testified for the defense, and yet she seemed very fair. She answered all questions. Yes, no. You've got to realize that as someone who's going to appear on the witness stand, both sides are going to ask you questions that if you answer honestly are going to help them. They do that on purpose. That's the process, okay? So a prosecutor and a defense attorney are both going to ask you questions and your answers are going to help them. They're either going to make you look bad or make the state look good, or they're going to make their client look good. But it's up for the jury to decide. Don't get in the middle of that process. You just make yourself look like an asshole. And this attorney, for as long as she's been practicing law and family law, she looks like an asshole. And you can tell that she's someone who doesn't litigate things often, and she likes to settle by her own admission. You can count on us to give you the best expert breakdown from a 29-year police detective. And also me, I'll be there as well. If you missed any of our trial coverage, make sure you go back and watch some of the videos from earlier this week, last week. If you have any deep dive questions about any aspect of this trial, we did like a 9-part series on the whole Donna Adelson trial. So if you've got a lot of time on your hands and you want to know everything there is to know, whether it's about the hitmen or Wendy being interrogated or Charlie's trial, we've got all those videos. So make sure you go back and watch them. Otherwise, stay right here on the Comm Center as we continue to watch with an elegant vim and vigor the trial of Donna Adelson. I thought that was pretty good.